Welcome, students, to Political Science 200. This is the second part of our lecture on First Amendment freedoms. As you will recall, in the first part of our lecture, we went over freedoms that are in the original body of the Constitution. Right? We went over your habeas corpus rights, bills of attainder, ex post facto laws, and we also started discussing the freedom of religion and the Establishment Clause, right? And we discussed the test that the last test that 5 justices of the U.S. Supreme Court agreed to when addressing Establishment Clause claims. And Natalie, do you remember the name of the test?
The lemon test?
The lemon test, exactly. And so, if somebody files a lawsuit and says the government is engaging in an establishment of religion, the court will apply, in theory, the lemon test. Mm-hmm. And in order to be constitutional, a statute must have a secular legislative purpose. The principal or primary effect must be one that neither advances nor inhibits religion, and it must not foster an excessive government entanglement with religion. So, that's the test that the court applies in Establishment Clause cases, in theory. Now, in practice, the court has been all over the place in recent decades. They can't agree to a different test other than the lemon test. So in theory, the lemon test is still good law, but in practice, it gets ignored a lot of the time, right? Mm-hmm. Okay, remember to speak clearly.
Yes.
Okay, good. Okay, so, let me give you a case, one more Establishment Clause case, right? We dealt with, the ones that always get a lot of attention, school prayer, and what has the court said about government-led prayer in school? Just don't do it. Exactly. Right. Now, students are free to pray on their own, but you can't have government-led or government-sponsored or government-coordinated prayer in school. So, I'll ask you about another Establishment Clause issue, and that is the tax-exempt status of churches. Right? Aha! So, churches do not have to pay things like property taxes, right?
Really?
Yeah, really. So, as a result, do other people have to pay more in property taxes because churches do not have to pay property taxes?
Yes.
Yes. So, a gentleman named Waltz bought a worthless piece of property in New York, right? Mm-hmm. And, it wasn't worthless, that's a joke, because he had to pay taxes on it. But he bought a small piece of property in New York for the express purpose of challenging the tax-exempt status of churches, right?
Oh boy.
And
just looking to cause
trouble. His case made it to the U.S. Supreme Court. It was Waltz versus Tax Commission of the City of New York. And the court looked at the situation, and they said the tax-exempt status of churches was just fine, right? Mm-hmm. And the reasoning they used was that it actually encouraged a separation of church and state, right? If religions had to pay taxes, then would the state be more involved in the church's affairs?
Yes.
Yes, exactly. And so the court said this actually helps, allowing churches to be tax exempt actually avoids the excessive government entanglement with religion that the founders wanted to make sure didn't happen. What do you think about that ruling? Good ruling, bad ruling?
I think it's good because also it does lend itself because it's also like you kind of need to keep it really separate.
Yes.
Because then
Yeah.
whenever it's just a slippery slope, and whenever you just get started on it, and it's like, well, where does it end?
That's right. If the government can start looking at our books and seeing how much money we have coming in and that type of thing, then that opens the door for a lot of government involvement. So it's just best that they stay as separate as possible. And so that ruling was really important because it was actually one of the rulings that kind of led up to the Lemon Test, where the court said government policies should not foster an excessive government entanglement with religion. Okay, so on we go to the free exercise clause, right? And this is a clause in the First Amendment that states that Congress shall make no law prohibiting the free exercise of religion. So, a couple questions. Number one, are you free to believe whatever religious principles you want?
Indeed, I am.
Absolutely. The U.S. Supreme Court has said repeatedly, whatever goes on between your two ears when it comes to religion is your business, right? It's no affair of the government's, and people are 100% free to believe whatever they want. But the U.S. Supreme Court has said, in the nature of things, people aren't necessarily free to do whatever they want, even if it is required by their religion, just because you may interfere with other people's rights.
Makes sense.
Makes sense, right. So, for example, can you engage in human sacrifice if it is required by your religion?
Not in this government.
No, not in our country, absolutely not. Why not?
Because it's murder.
It's murder. You interfere with the rights of others. You interfere with the life, liberty, and property of other people, right? Mm-hmm. Specifically their life. So, your free exercise rights are not absolute, right? Now, what does that phrase mean? Your free exercise rights are not absolute.
I can't just do anything.
Correct. You can't just do anything you want just because your religion requires it, right? So, as long as we're on this point, basically, almost none of your rights are absolute, right? Your free speech rights are not absolute, right? For example, you can't lie under oath, all right, right? You can't give secrets to our political enemies, and other things like that, right? So, even though the First Amendment is couched in very absolute terms, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. In the nature of things, there are limits on what you can say and what you can do. And in the religious sphere, what religious practices you can participate in, right? Kind of the leading recent, most important case dealing with this. If you take me for constitutional law, we'll talk about a lot of free exercise clause cases. But in this class, we don't have time, so we'll just look at a leading case or two. The leading free exercise case in recent decades was Oregon Employment Division, Department of Human Resources of Oregon versus Smith, right? And there were these two guys. Ironically enough, they were counselors at a private drug clinic. but they were Native Americans, and their religious beliefs required them to use peyote, right? Which is a drug. It's a hallucinogen, right? So what do you know about peyote?
It's called peyote.
It's called peyote. Okay, you until recently here, you were going to high school. I'm sure kids have talked about pot and other things like
Kids
that.
get caught with it.
Yeah. How many kids are talking about peyote?
Not many.
No. Have you heard any kids talk about peyote?
No.
No, and the reason that you haven't heard kids talking about, hey, let's go use some peyote, is if you want to hallucinate, there are better ways to do it than taking peyote. Peyote is bitter. It induces nausea.
Ooh.
And so if you just want to hallucinate, if you just want to go trip, there are better ways to go do it than take peyote. But these two gentlemen used peyote as part of a religious ceremony that they felt was required by their church. They felt that peyote use was actually a sacrament, much like in the Catholic Church, wine is part of the communion service. So, if you're Catholic, you believe in taking wine and a wafer to represent the blood and body of Christ. These gentlemen believed in using peyote for sacramental purposes. Now, is alcohol a drug?
No. Substance.
Alcohol is a drug.
Not really, though.
Yeah, we can argue this later. Most definitely, alcohol is a drug.
If you say so.
Okay, whatever. Alcohol is a drug. It's legal. It's taxed and regulated. In Oregon, right, peyote, which is also a drug, was treated very differently. It was made illegal. And so, when these two gentlemen used it, their employers found out and fired them. Right? They then went to go collect unemployment benefits, and they were denied unemployment benefits because, according to the state, they had been fired for cause. They were not laid off because of lack of production and they weren't needed anymore, you know. They weren't laid off because there was a downturn in the economy or something like that. They were fired for cause because they broke this state law. So they filed a lawsuit saying we're, being denied these unemployment benefits for practicing our religious beliefs. Whereas other groups, more mainstream groups, are allowed to practice theirs. So the case went to the U.S. Supreme Court. The court listened to the arguments, and the court said, we're ruling for the state in this situation. These two gentlemen are out of luck, and the court basically applied what has come to be known as the valid secular policy test, right? So, if the government passes a law that interferes with the free exercise of your religion, as long as it is a valid, neutral law of general applicability that's trying to accomplish a secular purpose, and it's not targeted at any one particular religious group, then you have to abide by it, even if it interferes with the free exercise of your religion, right? So, valid. Is fighting drugs a valid secular government objective?
Yeah.
Yes. Is the law neutral with respect to believers and non-believers? Does it apply to everybody?
Yes.
Okay. So it's a neutral law of general applicability, and was it targeting any one religious group, or does it just apply to everybody again?
It applies to everybody.
It applies to everybody. So the court upheld it, right? Now, that is how the court has interpreted the free exercise clause. Do you think that gives you a lot of constitutional protection, or not that much? Not that much, exactly. Remember what I said. Speak clearly.
Not that much.
Not that much, exactly. And that was the concern a lot of members of Congress had. Now, this next part of the lecture, don't worry about memorizing or anything unless you take me of constitutional law, in which case you will. So, after this court ruling, Congress actually responded with the Religious Freedom Restoration Act. And they said, basically, we kind of liked the way the court was approaching free exercise claims earlier. Right? And again, in this course, I don't have time to go through it all. But they said, basically, if the Congress passed a law, Religious Freedom Restoration Act, that said if any government entity is going to substantially interfere with the free exercise of someone's religion, then the policy or the law must be the least restrictive means of accomplishing a compelling government objective, right? Mm-hmm. And so, cases went to the Supreme Court dealing with the Religious Freedom Restoration Act, and the court basically said the Religious Freedom Restoration Act can't be forced upon the states, right? But the Religious Freedom Restoration Act, because it was passed by Congress, can apply to the federal government and all of its entities, such as Customs, U.S. Customs, and Border Patrol Enforcement, right?
Yeah.
So they have to abide by the Religious Freedom Restoration Act. The federal government and all its entities. Any question on that?
No.
All right. Okay. Now for some interesting cases. Freedom of speech. So today the Supreme Court holds that all speech is protected unless it falls into one of four narrow categories: libel, obscenity, fighting words, and commercial speech. And sometimes these four areas are lumped together by some scholars and called non-protected speech. They're not protected as much as other types of speech. So, let's just talk about freedom of speech for a moment. At the time of the founding, the founders had a clear hierarchy of speech in mind, right? At the top of the hierarchy is political speech and social speech, right? In the middle was kind of commercial speech and speech for entertainment purposes. And at the bottom is libel and obscenity, right? And so keep that in mind. The founders wanted political and social speech to be protected as much as possible. But, quite frankly, other types of speech weren't as important to the stability of our society, to having a vigorous, robust political debate in a society. So keep that in mind. All right, so talk about kind of these four areas of non-protected speech: libel, obscenity, fighting words, and commercial speech. So let's start with libel. Now again, the Supreme Court has uniformly held that libel is unconstitutional. And libel is written defamation of another person, especially in the case of public officials and public figures. The constitutional tests designed to restrict libel actions are very rigid. Okay, so let's start with the most famous U.S. Supreme Court dealing with libel, and it was New York Times versus Sullivan. All right, and kind of the background is a number of people that were concerned about the civil rights movement and supported the civil rights movement and wanted to generate more support for the civil rights movement, they took out an ad in the New York Times talking about the civil rights struggle and a lot of the things that were happening in southern cities like Montgomery, Alabama, where you have police dogs and fire hoses and all these types of things. And so the ad said, the police are engaging in a lot of atrocities in these southern cities. Wake up, make a donation, help out. And the ad was very critical of the police in Montgomery, Alabama. Well, this guy named Sullivan was a commissioner, and he was responsible for the police. And so even though he wasn't mentioned by name, he said, my character is being attacked here. I'm being criticized. And so he filed a lawsuit.
Don't tell me.
Well, this is in Alabama. Yeah, he's going to win. Absolutely in Alabama. And so this was in Alabama. Case went to a court in Alabama. And the judge instructed the jury and said, this ad contains falsehoods, which it did. For example, it said that the students sang My Country 'Tis of Thee when they actually sang the Star-Spangled Banner. Right? So, yeah, I know. So there were mistakes. So he said it's libelous per se. That means through itself, by definition. So you as a jury have to decide, were the statements false? Yes, they were. We've determined that. Were they damaging to Sullivan's reputation? And if they're false and damaging, then Sullivan is entitled to an award. So keep in mind this is back in the 60s. And guess how much an Alabama jury awarded him because this ad criticized the police and he was in charge of the police?
A lot.
$500,000. $500,000. Back, I know. And that
Are you serious?
Yeah, and that was back.
That's ridiculous.
That was back in the 60s, in the civil rights era. And the New York Times said they filed a lawsuit. And they said, look, we're not going to be able to survive if we have to pay out $500,000 awards every time we make an honest mistake. If you're the New York Times and you're publishing all the material that it does in a given day, are you going to make some honest mistakes?
Yes.
Yes. Were they lying on purpose?
No.
No, they weren't lying on purpose. So they said, especially in cases of public officials and public figures, you got to do something to protect us. Otherwise, the press is going to go out of business. So the Supreme Court heard the case, and they ruled for the New York Times.
Let's go.
Yeah, exactly. Go Supreme Court, right? And they said, libel law is fairly undeveloped. But from here on out, especially dealing with public officials and public figures, if someone thinks they've been libeled and they file a lawsuit, then you're going to have to prove that the statements were false, damaging, and if you're a public official or a public figure, you're also going to have to prove that the statements were made with actual malice. That is, with a knowledge that the statements were false or with a reckless disregard for whether they were false or not. So in other words, you're lying on purpose to go after the person, to criticize them, that type of thing. Right? What do you think about that standard? False, damaging, and made with actual malice.
Sounds pretty good.
Sounds good, and it's what we've had in place ever since, right? And so they said, this standard ought to give newspapers the breathing space that they need in order to function responsibly in our democracy. Do we need the press in order to keep a watchful eye on government?
Yes.
And the criminal justice system? Yes, both of those. So, we need the press in a free society, and so this gives the press more leeway, a lot more leeway, right? Okay, now the question becomes, what do you mean by a public official or a public figure? Since we're in Alabama, we gotta tell this story. If you take me for con law, we'll worry about the names. But there was a case that reached the court after New York Times versus Sullivan. And in this case, an Atlanta insurance salesman said that he overheard the athletic director at the University of Georgia giving all the football plays to Paul Bear Bryant at the University of Alabama. I know. He said he overheard them speaking. He overheard this conversation, and a media outlet took him at his word and published a story about it, right? So all they had as evidence was what this Atlanta insurance salesman said he overheard. Okay, so one of the main things the court wanted to tease out in this case was, how far down the government hierarchy do we go and someone's still considered a public official or a public figure, and the New York Times test applies, right? So an athletic director, which it's not an elected position, right?
No.
But at a public university, the University of Georgia, which is a huge university. Mm-hmm. So the athletic director at a public university, do you think that is a public official or a public figure?
I do.
Yeah, and that's what the court said as well, right? So they said basically the New York Times test would have to apply in this case. Which my understanding was, even applying the New York Times test, the athletic director won because he could show that the statements were false, damaging, and made with actual malice. That is, with the knowledge that the statements were false or with a reckless disregard for whether they were false or not. So just going with what one insurance salesman says without giving the athletic director a chance to respond, or Paul Bear Bryant a chance to respond, or checking up on any additional facts, the record showed that they had done very little to follow up on the guy's story. Is that a reckless disregard for whether the statements are false or not?
Yes.
Yes, it is a reckless disregard for the statements were false or not. So, in that situation, the guy won. And the reason I didn't mention his name like that is his name was Wally Butts. Students between teaching college and other levels. You never get anywhere after that. You may as well wrap class up. Okay, so now let's turn to obscenity. That's the quality or state of work that, taken as a whole, appeals to prurient interest in sex by depicting sexual conduct in a patently offensive way, and that lacks serious literary, artistic, political, or scientific value. Okay, that is a long definition of obscenity. Mm-hmm. Right? It took a long time for the court. a lot of blood, sweat, and tears went into coming up with this definition of obscenity. Which, again, if you take me for constitutional law, we'll go through all those cases. But the point is, this is where the court is now with this definition, right? along the way, some justices got so frustrated that they said, I'm not going to try to define obscenity again, but I know it when I see it. Right? That was Potter Stewart's famous definition of obscenity. I know it when I see it. Well, that doesn't give prosecutors a lot of guidance on when someone has violated obscenity laws or not, right? So the court's got to give prosecutors a little more guidance than I know it when I see it. And so that's the definition that they've come up with. So let's take a look at it. Quality or state of a work that taken as a whole appeals to prurient interest in sex. By depicting sexual conduct in a patently offensive way, and that lacks serious literary, artistic, political, or scientific value. Okay, so, again, if you take me for common law, we'll go through all the cases that are really important dealing with obscenity. I'll just give you one or two kind of interesting ones that happened along the way. One of the cases along the way dealt with, how much social value does a work need to have in order to not be deemed obscene, right? Mm-hmm. And so it was called, the case was called Memoirs versus Massachusetts. And it dealt with a book. It was called Memoirs of a Woman of Pleasure. And she was a prostitute hundreds of years ago. And so, do you think that account has some literary or historical value?
Yeah.
Yeah, probably just because it's from so long ago.
Yeah. Right?
And so the court in that case said, as long as something has a modicum of social value, it can't be deemed obscene, right? Do you know what a modicum is?
Tiny bit.
Tiny little bit, right? So as long as something has a modicum of social value, then it can't be deemed obscene. Okay, well then, people that made like hardcore pornography and things like that, they started getting really creative, and they started putting like classical music in the background of hardcore pornography,
like Randy Max and Parks and Rec.
Yeah. Shakespearean sonnets, whatever it is, but they're like, oh, well, see, now it has a modicum of social value. It's not utterly without redeeming social value, right? And so that was the standard for a while, right? As long as something had a modicum of social value, it couldn't be deemed obscene. Well, in the court, in the case that the court finally heard where they said, look, this is going to be the standard, right? It was called Miller versus California. They said, if a work lacks serious literary, artistic, political, or scientific value, and it portrays sexual conduct in a patently offensive way, then it can be deemed obscene, right? So, say you have a hardcore porn, but it has classical music in the background. Does it lack serious literary, artistic, political, or scientific value?
Yes.
Yes, it does. So that's a good example of how the court's definition of obscenity evolved, right? Any questions on that?
No.
Nope? Okay, so you're good on obscenity stuff. Okay, now let's talk about... Wait, actually, one more thing to mention on obscenity. The case was Miller versus California. It was heard during the Burger Court era. And remember, Nixon ran in 1968 on a law and order campaign, and Nixon was tired of that liberal Warren court protecting obscenity and things like that. And so once Burger got in, the court heard a case dealing with obscenity, Miller versus California. They tightened up the definition, and they said basically we're going to turn this over to the states. And it's up.
Really?
Yes. It's up to the states to define more specifically what they mean by obscenity in applicable state law. So, in Miller versus California, the court declared victory and departed the field. As I said, we're dumping this down to the states. It's a state issue. You protect the health, safety, and welfare of your citizens. We're done having movie days watching these obscene films and trying to determine whether they're obscene or not, right? Okay. On we go now to fighting words. Words that by their very nature inflict injury on those to whom they are addressed or incite them to acts of violence. Okay, so basically the leading case here, and it's still applicable, it was decided back in the 40s. It was called Chaplinsky versus New Hampshire. And keep in mind this was the 40s. And Chaplinsky was a Jehovah's Witness, and he was out proselytizing, doing his thing. And what do you know about the Jehovah's Witnesses? Keep in mind this is on YouTube, so.
Yeah. I don't know a lot, if anything.
Okay, that's a safe answer. Okay. All right, so just so you know, Jehovah's Witnesses believe it is a part of their responsibilities as a Jehovah's Witness to actively proselytize to others, right? Tell others about their beliefs and warn other people, that type of thing. Another thing to know is in the process, they can be somewhat critical of other religious beliefs, right? And churches, such as the Catholic Church. Right? So he was on a street corner doing his thing, and a mob started to gather. And it looked like things were going to get ugly. And a cop showed up, right? And it's kind of Chaplinsky versus everybody else. Well, if you were a cop and you were trying to restore order, what would you do? What would be the quickest way to restore?
Take Chaplinsky away.
Take Chaplinsky away, exactly, right? And so, what's an arrest? What is just removing Chaplinsky from the situation? It depends on your perspective. But basically, the cop proceeded to arrest Chaplinsky. And he said, "Why are you arresting me?" And the cop said, "Shut up." And he called him a damn bastard.
Oh.
I know.
Fighting words.
Well, fighting words, exactly, right? And so he started by calling Chaplinsky a damn bastard. And then Chaplinsky responded by calling him a goddamn fascist and a damned racketeer.
Interesting.
Yeah.
Interesting college course.
Salty language, right? Okay, so so the cops started with the name calling, but once you start calling cops names, that's not gonna help the fact that the cops started it, right? So Chaplinsky gets arrested. Mm-hmm. There was a New Hampshire statute that made it a crime to basically use fighting words on the streets. You can't say words that are gonna incite acts of violence, provoke others to retaliation, that type of thing. Case went to the Supreme Court, and the Supreme Court upheld Chaplinsky's conviction. And they said, there's a certain class of words, Dems fighting words, right? That they don't contribute to a robust exchange of ideas, right? Mm-hmm. They have very little social value, right? And they're basically just an invitation to exchange in fisticuffs. That's what the court said, you picture. So,
oh boy.
Yeah, so they said, what are fighting words? In this case and others, the court kind of used other phrases to describe fighting words. Direct personal insults. Words that by their very nature inflict harm. An invitation to exchange in fisticuffs. Words that can be expected to provoke the average person to retaliation. Right? So I know it's a Sunday and everything, but say someone called my wife a bitch, right? In the state of Alabama,
that's fighting.
Them's fighting words, right? And I'd be protecting my wife's honor, right? Just so you know, you're still not justified in responding with physical violence.
What?
I know. You're still not justified with responding with physical violence. But if a state wants to outlaw fighting words, they can. They're allowed to. Fighting words, right? It doesn't mean they have to. It's up to states to decide whether they want to outlaw fighting words or not. Right?
Alabama's sure not going to.
Right. Okay, so, you may or may not remember this, but this is kind of, I think it's funny. But a number of years ago, it's been a number of years now, since we got here to Alabama, on the very last day of our state legislature session, one of our state senators punched another state senator.
Whoa!
Yeah, and this kind of made national news because it's like, oh, look what happens in Alabama. And we make the national news again for all the wrong reasons, right? But, one of our state senators punched another state senator in our state legislature down in Montgomery, Alabama.
Dang.
Yeah, down in Montgomery, Alabama. This wasn't our 2 U.S. senators in Congress. This was down 2 state senators. And a lot of people are like, what? What the heck is going on? They're just kind of like...
What was happening?
Yeah, what was happening? And it turned out that one of the senators had called the other senator a bastard.
Fighting words.
See, because if you call someone a bastard, who are you insulting?
Their parents.
His mom.
Mm-hmm.
Exactly. So he said I was protecting my mother's honor. So in a way, people in the South are like,
Makes sense.
No, we can understand a little better. But anyway, so if states want to outlaw fighting words, they can. But it's kind of one of those things where it's left to the states.
What'd they say?
Oh, we won't worry about the aftermath of that. Okay, so now let's talk about commercial speech for a minute. Commercial speech or advertisements and commercials for products and services, they receive less First Amendment protection, primarily to discourage false and misleading ads. Can the government require food manufacturers to print nutritional information on their products?
Yes.
Yes, absolutely. Can the government prevent advertisers from implying that eating a cereal will give you magical powers or make you fly?
Yes.
Yes, and actually they've done that because kids will think, oh wow, if I eat this breakfast cereal, I'll fly, or whatever. And so the point is, government is allowed to regulate commercial speech, especially advertisements, quite a bit, right? Whereas, say I personally am on a date, first date with a girl, am I allowed to lie all the time? I can run a 4-4-40.
Yeah, you can lie about that.
Yeah, you're allowed to lie, exactly, right?
If you believe me, I have no idea.
Yeah. Exactly, yeah. And I once got a marlin that took me 3 hours to land. You can tell fish stories, run, exploits from your youth. But so individuals are allowed to lie.
Yeah.
Actually, as long as they're not gaining anything commercially by it, that type of thing. But you're allowed to lie. Okay, now let's talk about the freedom of the press for a minute. The Supreme Court has refused to acknowledge that reporters have a constitutional right to ignore legal requests such as subpoenas and to withhold information from governmental bodies. So in other words, the press is free to gather information, but no freer than any other individual. There's no right to know, right? And if you're subpoenaed, and if you're a reporter and you're subpoenaed, you have to testify just like anybody else, as long as you're not the person who's accused of the crime, right? Now, if you're the person who's accused of the crime, so I'm going to speak clearly. If you're the person who's accused of the crime, then you don't have to testify under the Fifth Amendment, right? You can't be compelled in a criminal trial to be a witness against yourself, right? But otherwise, if you're just being subpoenaed because you have information, then, and you're a reporter, you have to testify, just like everybody else. So the leading case dealing with this is called Brandsburg versus Hayes. Occurred a number of decades ago. What happened was this guy named Brandsburg was doing a story on drugs, their manufacture, use, production, distribution, all that type of stuff. And he promised to keep all of his sources anonymous. Yeah, well, he was subpoenaed, and he was asked for information on his sources. And he said, I don't have to tell you. I don't have to tell you. And they said, well, yes, you do. You're on the witness stand. You're not the one being charged with the crime. You have to testify just like anybody else. Otherwise, you're in contempt. And he said, I'm not testifying, right? Well, his case reached the Supreme Court, and the Supreme Court said reporters have to testify just like everybody else, right? Now, there were dissenters in the case, and they said, if we abide by this ruling, then no anonymous informants are going to come forward anymore, right? And the press won't be able to serve its function of being a watchdog, because anonymous sources won't come forward anymore. And the court said, it's too bad. They have to subpoena, or they have to testify just like everybody else. Any questions on that one?
Well, I don't like that one.
Yeah. Okay. Okay, we have a few more minutes. This will go over by just a couple minutes, but that's okay because you have plenty of time these days. So let's go down to freedom of assembly. Governments may not censor what can be said, but they can make reasonable time, place, and manner regulations for protests or parades. Reasonable time, place, and manner restrictions, right? Kind of the leading case dealing with this was National Socialist Party versus Skokie, Illinois. Now, National Socialist Party isn't a bunch of Bernie Sanders types. They're Nazis, right?
Ooh.
Yeah, and they wanted to march in an area of Illinois, Skokie, Illinois, that was where a lot of Jewish people lived. Mm-hmm. And so the town was kind of giving them the runaround and doing all types of things so that they couldn't get a parade permit. And so here's the thing. If they had been almost any other group, would the town have given them a parade permit?
Yeah.
Yes. Right?
Not this one, though.
Yeah, but they're like, sorry guys, no dice, right? Case went to the Supreme Court, and the Supreme Court told the town of Skokie, Illinois, you have to give them a parade permit, just like anybody else. You can't make, you can impose reasonable time, place, and manner restrictions. Your parade has to be at such and such a time on a Saturday morning. It can't get too loud. It can't exceed a certain decibel levels. But 10 o'clock on Saturday morning, so it doesn't interfere with traffic. And it can't be above certain decibel levels, so you don't interfere with a hospital down the street or whatever it is. See, those are reasonable time, place, and manner restrictions. Why were they denying them the parade permit?
Because of the beliefs of the organization.
That's right, because of the content of their message. Exactly. And so the court said you can't start doing those types of things. If you're going to have reasonable time, place, and manner restrictions, then they need to apply equally regardless of the message, even if it's a message that's unpopular. Make sense?
Yes.
All right. Now, the Supreme Court has divided public property into 3 categories: public forums, limited public forums, and non-public forums. So public forums are places like sidewalks, public parks, stairs of a court building, that type of thing. And the court has held that that's where you're entitled to the highest amount of constitutional protection, are in these traditional public forums. So you can basically say all kinds of things there, right? So back during the Civil Rights era, there were some students. The case was called Edwards versus South Carolina. It was a civil rights protest. Students were standing on the State House steps. Does that sound like a good place to peaceably assemble and to petition government for a redress of grievances?
Yes.
Yes. A particularly appropriate place to peaceably assemble and to petition government for a redress of grievances. So, a cop showed up, gave him a time limit, said, you have X number of minutes, then you gotta break it up and go home. And they said, we're not doing anything wrong. We're in a traditional public forum. Forget it. We're not going home. Well, they were arrested.
Uh-oh.
Yeah. Case can, yeah. Case went to the Supreme Court, and the Supreme Court said, you can't arrest these kids in this situation. It's a traditional public forum. They weren't breaking any local ordinances or laws. You can't just arrest them and tell them to go home because you're tired of their message. So, you're basically in a traditional public forum. That's where you can exercise your free speech rights the most. All right. So, take care, class. We'll see you in a couple days, and we'll have more interesting cases for you, and just constitutional law stuff and political science stuff. Take care. Bye-bye.